So what does the term historical allegation mean to you?
Something that happened in the past. Maybe it's outside. I don't know really if. I guess something that you can't necessarily prove today, but you think happened in the past.
What does the term historical allegation mean to you?
The fact that a rumor was spread about you before, right?
The fact that what?
A rumor could have been spread about you before, and I guess that means it can be used against you in the current case.
Did you know that Canada has no statute of limitations on sex crimes, and that anybody can walk into, email, or call a police station today to report that they were sexually abused X amount of years ago without having to pinpoint a specific date or provide any supporting evidence, as we have discussed earlier, that the alleged sex crime occurred?
I did know that we didn't have a statute of limitations. I was about to say statute of limitations, but that's why I didn't say it, because I knew we didn't have that. I did know that, and I guess for some people it's good because it takes some people a lot of time to build the courage to come forward. But again, same thing where you have the opposite side where 20 years later you can claim that, people all the time, they fabricate memories, stuff like that. Someone could be arrested off of a fabrication or something that's not real.
Did you know that Canada has no statute of limitations on sex crimes, and that anybody can walk into or email or call a police station to report today that they were sexually abused X amount of years ago without having to pinpoint a specific date or provide any supporting evidence that the alleged sex crime occurred?
You see, I thought I could rest when I'm 90, right? But you're telling me I can't even go into retirement anymore.
So how easy do you think it would be for an innocent accused person to defend themselves against a historical allegation that was said to have happened, say, 20 years ago?
It'd be pretty hard because people don't always remember. Police ask questions like, what did you eat that day? And you wouldn't remember from 20 years ago, which could end up being incriminating to you, because if you can't tell them what you know, then they find that incriminating.
How easy do you think it would be for an innocent accused person to defend themselves against a historical allegation?
It wouldn't be easy at this point.
Yeah, because there's issues with evidence, for exonerating evidence that could prove that you weren't there or you were somewhere else 20 years ago. That evidence isn't going to exist, right?
Yeah, at this point, lawyers need to invent a time machine.
Do you think an accused person should be convicted in a court of law when there is no evidence proving that the crime occurred other than the accuser's testimony?
No.
Do you think that an accused person should be convicted in a court of law when there is no evidence proving that a crime occurred?
Absolutely not.
What if I told you that most sex crime case convictions are based purely on a credibility contest rather than any actual evidence proving facts that a sex crime occurred?
I think it's sad, like I said in the beginning there when we were talking. I think it's really unfortunate because you see girls who are, trying to come forward with something that actually did happen to them, having their whole lives ripped apart. Their sexual history is what is determining whether or not the person is convicted. But then you have the opposite, where someone who maybe, they have a criminal past, maybe they've done things that weren't in their right mind. Somebody knows that and pins it on them, and they end up in an unfortunate situation.
So what if I told you that most sex crime convictions are based purely on a credibility contest rather than any actual evidence proving facts that a sex crime occurred?
Okay, I'm not surprised anymore.
So current legislation does prevent the defense from launching a vigorous campaign to discredit their accuser in the absence of any exonerating evidence, which does create an imbalance in discreditable facts presented in a court of law. The police and the Crown prosecutor have very little limitations when it comes to digging up dirt on the accused person to make him look like an unsavory character and therefore likely guilty of the accused crime. Did you know that a factually innocent person can still be found guilty of a crime in a court of law?
Of course.
Okay. Do you know what the term factual innocence means?
I do, yeah.
In a nutshell, insufficient facts pointing to a person's guilt.
Yep.
Okay. Current legislation prevents the defense from launching a vigorous campaign to discredit the accuser in the absence of any exonerating evidence.
How did they do this?
Well, it creates an imbalance in discreditable facts presented in the court of law because the lawyers are basically taught and disciplined if they re-victimize the victim by answering too many questions or digging into their past to create a scenario where they're most likely not telling the truth, or they're misremembering something, or their medical documents tell another story. Because the police, since they don't investigate, they don't look for these documents. They don't determine whether or not the accuser's story is credible or not. So the courts don't either. So when it comes time and you're standing before a judge, your hands are behind your back.
So what is currently the best way to defend against it?
Well, first of all, it's for you to understand exactly how the system works, and that's part of the reason for asking these questions. Understanding that also that there are, on average, about 20 known cases per year in Canada where a sex crime conviction is overturned because of a judicial error of some sort in interpreting the facts or applying the law.
And what does that constitute as a percentage?
There's approximately, I think, 6,000 people convicted a year on average. It's an approximate number. But 20 of those 6,000 is a small percentage. But these are cases that are actually overturned. So we don't know about the convictions that are upheld, that remain convictions.
In finance, if the stock instantly moved that much, it would be enormous.
What if I told you that on average, there are about 20 known cases per year across Canada where someone, mostly men, has their sex crime conviction overturned due to errors in judgment?
That wouldn't surprise me.
Okay. Have you ever heard of phallometric testing?
I haven't, no.
Okay. So phallometric testing uses a device which is called a plethysmograph. I may not be pronouncing that properly. And it's hooked up to a man's penis to measure the circumference while exposed to images of men, women, and children, and describe sexual scenarios to determine sexual attraction.
I have heard of that, but I didn't know the name.
Okay. Did you know that it's common practice for Crown prosecutors to order men convicted of sex crimes, considering the scenarios we have just discussed, against women or children, to be subjected to phallometric testing prior to their sentencing hearing or as a mandatory condition of their probation?
No, I didn't know that.
Do you know anyone that went to a psychotherapist and emerged with forgotten memories of childhood sexual abuse?
No, I don't know anybody like that.
Okay. Would you think that such memories developed during the course of therapy should result in going to the police?
It shouldn't result in a conviction. That's certainly true. Whether they result in going to the police, that's up to the person has a right to go to the police and they can say anything. We can't take that away, but it certainly shouldn't result in a conviction.
Do you know anyone that went to a psychotherapist and emerged with forgotten memories of childhood sexual abuse?
I do.
Okay. Would you think that such memories developed during the course of therapy should result in going to the police?
I don't know, because from a psychology standpoint, memories can be fabricated, memories can be changed. I mean, there are people who are eyewitnesses who are the lead defense witness who convict people because they saw that person, and 20 years later it's proven that they actually didn't. So I don't think that. I don't think that. I mean, there's even psychological studies that I've read about where you can, I think in one of my psychology classes we studied a psychologist who had planted diary entries into someone's diary and had them read the entries, and that person adopted the entries that weren't their own as their own memories without even realizing that these were fabricated memories and planted in their own journal, and they adopted those as their own. So no, I don't think that should be something that you could put someone in jail for.
Okay, well thank you very much. I really appreciate your
Yeah, no worries.
Thank you. Have a good day.
You too.